Good afternoon, everyone. I'm Rich Freer. I'm the Dean of Emory Law School, and it is my great pleasure to welcome you all to the second annual Carney Lecture. Special words of welcome, of course, to Professor Jeffrey Gordon of Columbia Law School, who will deliver that lecture. Today, we also celebrate the first anniversary of the founding of the William and Jane Carney Center for Business and Transactional Law, which is right around the corner within a few feet of where we are. The center was the result of the vision and unparalleled philanthropy of Bill Carney, who is the Charles Howard Candler Professor of Law Emeritus, and his late wife, Jane. Bill Carney is a visionary. Long before other law schools and long before the ABA was talking about experiential learning, Bill espoused the need for schools to equip students not simply with rigorous academic curricula, but with skills-based training. Almost 20 years ago, he founded our nationally acclaimed Center for Transactional Law and Practice, led by Sue Payne. And now, with the largest gift in our history, Bill and Jane have founded this broadly gauged Center for Business and Transactional Law. Bill and Jane made it possible for us to dream big. And the work of making that dream a reality has been led by my colleague and friend, Professor Andrew Jennings, who is the director of the Carney Center. It is he, in consultation and collaboration with others, who has implemented a robust programming and robust initiatives to engage far beyond this law school. And he is building this center into an international beacon. This fall, we will welcome to our faculty Professor Jiyoung Min, who is here today. Who will be affiliated faculty in the center. Bill himself sends regrets that he could not be here today. Bill suffered a fall a few weeks ago and is recovering, and sends his warmest regards. If you have contact with Bill, I suggest an email to him today. He would love to hear from you. So again, welcome to this wonderful event, and I am delighted and honored to turn the podium over to Andrew Jennings.
All right, thank you, Dean Freer. Although Bill wasn't able to join us today, his presence is felt in this program, because during the fall, as he and I were talking about what the second Carney Lecture should look like and who we should invite as our distinguished lecturer, he nominated his friend and colleague, Professor Jeffrey Gordon of Columbia Law School, whom we are pleased and honored to have with us today. And it's not hard, based on Professor Gordon's distinguished career, to see why he is Professor Carney's nominee for this year's lecture. Professor Gordon is the co-director of Columbia Law School's Ira M. Milstein Center for Global Markets and Corporate Ownership at Columbia Law School. In his teaching, he teaches and writes extensively in corporate governance, mergers and acquisitions, comparative corporate governance, and the regulation of financial institutions. He also, if all that isn't enough, serves as co-director of the interdisciplinary Columbia Center for Law and Economic Studies and the Richard Paul Rickman Center for Business, Law, and Public Policy, which is a joint program between Columbia Law School and business schools. He's a longtime fellow of the European Corporate Governance Institute, or ECGI, the international scientific nonprofit association where academics, legislators, and practitioners debate major corporate governance issues. And I think we'll have some major corporate governance issues addressed in today's talk. Professor Gordon joined the Columbia Law School faculty in 1988 after 6 years at the NYU School of Law. Before becoming an academic, he was a clerk at the U.S. Court of Appeals for the 10th Circuit, an associate at a corporate law firm in New York City, and an attorney with the U.S. Department of the Treasury. In addition to teaching at Columbia, Professor Gordon is also a visiting professor of law at the University of Oxford. In just a few moments, I'll welcome Professor Gordon to the podium to deliver his Carney Lecture entitled The Moral Duty of Directors, which I understand might be the foundation of a future book project, so keep an eye out for that as it comes to press. And then because this is a corporate speech, a corporate lecture that has some moral and normative implications, I thought it would be appropriate for a member of Emory's distinguished law and religion faculty to offer some commentary on Professor Gordon's lecture. And so we'll be pleased to have commentary by Professor Michael Broyd after the lecture, and then after that commentary, we'll have some time for audience Q&A. So if you all please join me in welcoming our distinguished lecturer, Professor Jeffrey Gordon.
Thank you. It's really a pleasure to be here. When I first began to teach law at NYU, Bill Carney was a visitor, and I tried very hard to recruit him as a colleague. I was not successful, and Emory's been the beneficiary of my failure of recruitment at that time. But I certainly had warm thoughts about his role in legal academia then and since, and it's great to hear that he's voted with his feet, as it were, in favor of what Emory is now doing, and so I'm really honored to give a lecture on his behalf, I guess. So let's see. Okay, good. This is a time of great unease about the role and responsibilities of the large firms that organize the economic life of the modern world and therefore have an influential role in social life in a general way. For a long period, roughly 35 years, the pursuit of shareholder value has gained force as a sufficient guide for the behavior of the managers and the board of directors. And over that period, apart from exhortation, we've put in place a series of devices designed to align the economic interests of the shareholders as well as the key decision makers within the firm, particularly through stock-based pay. So the CEO and the C-suite executives receive large stock option grants, many employees do, and stock-based pay is now common for directors. So what we've seen is a concerted effort to align the interests of all the important actors of the firm along a single dimension and offer that as an explanatory basis for and a guide for their action. So what are the sources of unease about this? I think there are two main sources, one of which is a distributional concern, reflecting the share of equity ownership in the hands of the top 10%, the 1%, the 0.01%, and in parallel, a shift in the national income share in favor of the stockholders and adverse to the employees. The second is in the headlong pursuit of shareholder value. I think there's been a trampling of important social norms that are legitimately part of the rules of the game, as Milton Friedman might have put it in his famous New York Times essay. And one very visible change in social norms is with respect to layoffs of the employees in a profitable firm. So a generation ago, firing the employees en masse, for that's what a layoff amounts to, would have been taken as a signal that the firm was facing economic distress. But beginning with the much heralded success of GE's CEO Jack Welch, so-called Neutron Jack, CEO from 1981 to 2001, employee layoffs came to be regarded as the hallmark of a management team that was constantly evaluating strategy and making employment decisions accordingly. So for reasons that I'm going to develop later, I think that particular fact helps frame some of the argument for why the questions about the moral duty of directors seem urgent to me now. So let's just look in a quick way at the distributional facts. The question is, who benefits, in effect, from a dollar gain in shareholder value? Understand, first of all, that 40% of citizens, adults have no direct exposure to equities at all. And the remaining 60% benefit from shares they own directly and also appreciation shares that they own indirectly, including from defined contribution pension plans. So let's look. So basically, this tracks changes in effect, who benefits from an increase of a dollar change in shareholder value over a long period of time. And what you see is the top 10% have 90% plus of the domestic equity ownership share. And everybody else has got, what's left, the 10% share. So and what we see further is the concentration of the top 1%, that's the blue line. And so it's now over 20%, but the top 0.01% is a very tiny group, the number of those. And the top 1%, again, a very small group, has essentially 55%. And sort of like, the difference between the 90 and the 99% has got the balance. And part of the distributional change here is reflected in the fact that there's been an enormous appreciation in share prices over this period. So there's been roughly an 8-fold increase in shareholder value in real terms over that period. And one measure of it is stock prices at the beginning of the period in 1970 were about 1 times GDP of the time. Today, the market cap is 2 times the GDP of the time. And so while the ownership stake of the top 10, 1 and 0.01% has increased, the dollars involved have increased even more, which leads to very significant shifts in who benefits from an increase in stock prices. Okay, so this is quite a revealing chart. So this is the growth in per household equity ownership by wealth percentile. So basically, at the bottom, we see the median equity household growth index. These are folks who actually own shares. Remember that 40% own nothing. And we see that the rate of growth has got a heavy skew in favor of the 0.01% over the period, which are, quite meaningful effects. Right, and so what this shows, in a way, the shareholder value era really began in about 1990. The hostile era began in the 80s, and we had the seminal cases, Unicow case, Time Warner case, which purportedly gave the boards power to resist a takeover bid. But what happened in the following period is the institutional investors dealt with that legal issue by changing the name, changing the frame, the type of executive comp to be stock-based pay. So basically, as the level of stock-based pay goes up for the C-suite executives who make decisions in this regard and the boards, instead of exercising the legal right to push back a hostile bid, they're eager sellers. And that's part of the story of the appreciation and the distributional effects that we see that we see today. So this shows the effect in household effects of the changes that we see. So basically, the top chart, or nominal dollars, the bottom chart are inflation adjusted. And what we see is that the bottom 90% in actual household wealth change obtain almost nothing over that whole period. Almost none of the shareholder gains that I've described are going to the bottom, not 90%. The top 90 to 99% are doing all right, but it's really the top 1% on a household basis that is obtaining a significant part of the gains that we see. And part of this is reflected in this table here, which you see the dollar gain. So the bottom, the median share holder started off with $6,000 of equity value in 1970, now has 70, not bad. But you compare the top 1% going from 450 to 19 million. And again, we see that there are some gains at the bottom part. If you own shares, you're going to have appreciation. But the lion's gate of the gains are going in with a distributional skew. What that means then, this is the logic of it, is that the pursuit of shareholder value as a worthy social and political value depends really upon a kind of trickle down. That in pursuing share value, you will actually improve the well-being of those who don't own that much in the way of shares, which basically is really a sort of an income claim, really. And what we see is that the labor share of national income is declining in the period. So there is a significant increase in income, to be sure, but most of the gains are going to the equity owners. And the labor share, which had been stable for 50 years, is now shifting in a significant way against employees in favor of the shareholders of the firm. Okay, so, all right, so that's one general set of concerns that I have. The second relates to the shareholder value pressure that undermine the social norms that protect employees' sense of security at the job. So as as I telegraphed, for a long period of time, employment was stable upon good behavior at most firms. And indeed, that was essentially the labor contract that existed from the 1940s through the 1970s. But again, that changed with GE, it changed with IBM. And some of the shift in employment stability were from genuine shocks. The airlines were deregulated, as was trucking, but a lot of it, again, is a major shift in how firms treat the idea of employment security is measured against share value. So what this chart reflects is the percentage of layoffs that occur at firms that are making money. And so what we see early in the period, that layoffs generally occurred at firms that were having financial distress. Later in the period, and this is obviously a COVID era thing, the 2020, but what we see is by now, most of the layoffs that we observe are for firms that are making money, that are not facing financial distress. And the fact of these layoffs is part of the management behavior in response to the shareholder pressure. Okay, so that's kind of a kind of a statement of a little bit why one might be concerned. And so for those who are familiar with the Friedman argument about the duty of the firm, the duty of the managers is to maximize profits, how does that fit against the story? He was writing in the 1970s at a time when employment stability was assumed as part of the rules of the game. He was responding to claims. This was after the riots that occurred that destroyed cities, and firms were receiving requests that they oversee the building of cities, take on responsibility for reorganizing society. Those were the efforts that he was resisting. So I don't think it's fair to infer from what he writes that he would have observed this employment change pattern and say, aha, that's exactly what I had in mind, because he was writing at a period when the expectation was really completely different. Okay, all right, so this brings me to, in a certain way, the theme that I want to really develop here. To me, the current debates about the presumptive priority of the shareholder value norm are incomplete because they omit a serious account of human agency, that people working inside these firms are making decisions. There's not algorithm automatons. I've used AI actually to put together these charts, and it's great, but I'm not in favor of making ChatGPT or Claude Code as the maker of business decisions. And I think the idea of these automatic contracts that some folks are proposing is just, exactly the wrong way to go. I want to say a word about incentives, which are really important to the corporate law debate today. They're widely used in economic organization, key to measures of shareholder value creation. I've argued for this myself. Yet, the fact that one has an incentive to act in a particular direction is not a license to act in accord to fulfill that objective. Generally, incentives are not a justification for the action that they may incentivize, right? Grades are an incentive for students to study hard and learn more. A payment offered to an instructor is as an incentive to give the student a higher grade. That's also an incentive, right? But we call that a bribe because the underlying objective is illegitimate. So to claim that an officer director has an incentive or directors have incentives, so what? The question is the action which the incentive gives reason, an incentive to engage in is a legitimate one. And if it's not, the incentive is poison rather than a good thing. Anyway, so I want to, again, focus on this issue of moral duties, and I want to claim that the moral considerations are legitimately part of the game and a further essential part of legitimation of these firms. I want to be clear. These are moral duties. These are not enforceable in law. I don't want shareholder derivative suits on the basis that some, director, violated a moral code. That's not what this is about. This is buttressing the idea that people make decisions, and the basis on which they make those decisions take account of the full range of human responsibility and agency that they have. The business judgment rule is not a moral get-out-of-jail-free card. So, first, start with this. A sole or controlling owner has moral duties with the operations of the firm. If you're the sole owner, the fact that you want to maximize profits is not a justification necessarily for actions that you take in regard to that with respect to the action. And the claim I want to make that if the ownership of the firm is dispersed, then the obligation of moral duty is conserved. And the place where it is conserved is the board of directors. And the second claim is that the basis for the director's moral deliberations should be on an all-considered basis, not a restricted set of reasons. I don't like the idea of role morality. The third claim is that there's a limitation in the scope of the director's moral duty for the potential, where the potential for harm is material. And along the way, you know, I buy into the idea of an adaptive version of the doctrine of double effect, in which an action that's intended for a desirable goal may nevertheless cause some harm, which is morally permissible if the harm is not disproportionate to the intended benefits. The fourth claim is that any action that directors take on the basis of moral grounds, even at the expense of maximizing profits, will be protected by the business judgment rule. My assumption is that any of those actions would be taken to avoid third-party harms that would avoid the imposition of externalities. Corporate law simply does not require business to operate in a way that results in third-party harms, even if that would maximize shareholder value. And then another claim is that what legitimates this is really that there's shareholder voting. If directors take actions which they claim to be on moral grounds, ultimately the shareholders can fire those directors, right? It's not like I think the directors have protected stake here. You know, we live in a society in which the shareholders vote. Directors are not appointed as czars to make these decisions, but nevertheless, the process of deliberation by directors, the actions taken by directors, can affect the climate in which the shareholders, in fact, are voting. Anyway, there are also issues involved in complicity. Suppose, you know, directors have a view and the board has another view. There are two cases that I refer to, and, you know, we're running a little bit out of time. One of which is the Twitter case, and the second of which is the Fox News case. And I sort of want to say a little bit about directors faced with the sale of the firm. All right, so start first with the idea of a firm that's 100% owned and controlled by a single person. And the sole owner decides to build a low filtration chemical plant as opposed to a high one to maximize profits. Is there any doubt that he bears the moral responsibility for the harms that may be resulting from the choice to build the low quality filtration plant as to the high one? And the claim is the moral responsibility for decisions of that sort, even if the firm is sold off, even if ownership is dispersed, is retained, and it's conserved in the board of directors. So I think that's an important claim. Who would argue that one of the great advantages of the public sale of securities is that it eliminates the moral responsibility of the owner to look after the affairs of the firm, right? Wow, that would be one, right? I used to be responsible, I sold it off, and now, you know, anything goes. What a claim to make, right? This is why I claim it's conserved in the board of directors. It has to be. As I've worked on this talk, I've come to think that there's a second independent ground for directors' moral duties, and that is the legitimating function of moral considerations in business decision-making, in which a structure in which almost all the gains go to those at the top. So let's go back to the earlier figures and imagine who gets the benefit from a $1 increase in the stock price. Look at this new figure, which ChatGPT helped me put together. So basically, this is over time. In effect, when you allocate the gains from pension plans and other things, who benefits from an increase in stock prices? So the growing blue are foreign owners. The orange is a not-for-profit share. The green, the red is the 90%. The green are public shareholders. Everybody else, the bottom, not 90%. So how will it be politically sustainable over time to have an economic model in which almost all of the benefits from the appreciation are going to be absorbed for the benefit of the 90% and others? And, 90% of the electorate gets very little and indeed a declining share over time. So the claim that I want to make is that injecting the moral agency of directors is one way to buttress the legitimacy of this decision, because people will come to believe that the decisions involved are not solely the result of parties who just want to increase their share of this, but rather by directors who have an all things considered approach to the business decisions being made. So on the cases, the cases here on the Twitter board. So it was a great deal for Twitter. The Twitter directors were not obliged to sell, and they had a corporate governance machinery that actually protected them from a hostile bid by Musk. So my analogy to this is, suppose directors, target directors were thinking about selling to a company which said, you've got this very high quality filtration plant, chemical plant, filtration plant, and we want to replace that plant with a low quality filtration plant. That's how we're going to make the money. That's going to be the synergy gains that drives the M&A. Well, the board is completely, I would say, morally obliged to reject that deal. Well, in effect, that was the Twitter case, right? Part of what Musk predictably wanted to do is to eliminate the high-quality filtration system, the moderation system, which protected social media in this particular way, with a low-quality system in which there was no filtration at all. And so it seems to me the Twitter directors bear full responsibility for the problematic space that has thereby been created. When it comes to the directors of Fox News, there is now an extensive social science literature that tracks the so-called Fox News effect on the diminished precaution throughout the COVID period, the reduction of vaccination, the predictable increase in morbidity and mortality, the increased rate in hospitalizations and long COVID. The claim that I would make is that directors of that firm had some duty to be aware of the broadcasts and bear responsibility for their willingness to allow misinformation to be transmitted, which had the predictable effect of reducing health outcomes for many of the listeners. The final point I want to make, and this is kind of a, I pride about a little cleverness here, as to how the target board can, within the context of the Revlon case, which requires ordinarily the board to seek the maximum price when they're selling the firm, can behave in a moral way. So if bidder one shows up and the board enters to a friendly agreement, which there's, say, protection against employee layoffs or other sort of transition relief, that predictably reduces the premium that the shareholders of the target will be receiving, all right? So that, at one level, is inconsistent with the Revlon duty to maximize solely for the shareholders and not pay attention to other constituents. So if bidder two shows up, bidder two would be able to get an injunction against this particular feature, a tin parachute, it's sometimes called. There's no doubt about that. But if bidder 2 doesn't show up, perhaps it doesn't want to incur the reputational effects of saying, well, we're prepared to pay a higher price, but part of our gains are going to be pursuing these harsh attitude about the employees, which otherwise would have been protected. Bidder 2 may just not show up. Well, the shareholders of the firm may think about suing. What's going to be the scenario? The target in the proxy statement designed to obtain the shareholder approval for the merger with bidder 1 will have presumably extensively disclosed the protections that it's put in place for the employees. And guess what? We now have a case, the Corwin case in Delaware, which says that a approval vote by a majority of the shareholders after, again, full disclosure, can exonerate the directors from claims, a liability claim for breach of the fiduciary duties. So what you have is the shareholders who are happy to take a 20% gain, maybe not a 30% gain that they otherwise could have had, take a 20% gain, their approval vote for merger, which again fully discloses the way that the directors have protected the employees, exonerates them from the breach of fiduciary duty. The point I want to make is this doctrinal move that I offer opens up the moral space that directors have when they're negotiating a friendly deal, right? So it was always thought that directors had moral decision-making autonomy if there was a decision to sell the firm at all. They could just say no. The Twitter directors could have just said no on moral grounds. But the thought is, well, if we're selling the firm, we can't. But what the workaround that I offer I think reopens the discussion about what the moral responsibility of directors is, even in the case where the firm is sold. Anyway, so I want to leave space for my discussion and to hear from you. Thank you very much.
All right, thank you, Professor Gordon. And for those in my BA class, we're going to start talking about mergers and acquisitions on Monday, and I think Professor Gordon has really set us up for that conversation. And as the project continues, thank you for giving us this first look at it. I hope that I can have your favor to come on to the Business Scholarship Podcast for your book tour. It's now my pleasure to introduce my colleague, Professor Michael Broyd, who will provide some discussion and commentary on Professor Gordon's lecture.
Thank you so very much, Professor Gordon. And I want to very much join the others in thanking Bill Carney for his incredible donation and his many years of contribution to the law school. We wish him a full and complete recovery, and we look forward to him being at the third Carney Lecture, even if he can't be at the second. I work in the field of law and religion and not in the field of corporate law, but I want to very much endorse the underlying claim that Professor Gordon made. The Jewish tradition, where I come from, strongly believes that corporate responsibility is moral and not solely economic, and it recognizes that corporations and their directors bear a moral responsibility for the consequences of their activity, not just in the context of shareholder value, but also in the context of their culpability for the decisions that they have made as directors. This idea that you have to watch out for your employees deeply resonates with the Jewish tradition. The idea that social justice plays a role in corporate decisions is in the Jewish tradition. The retributive justice tradition, which I'll broadly call tzedakah, in the Jewish tradition, which is easy to translate as charity, has the same linguistic origin as the word justice. This idea that corporate responsibility has a distributive justice component, making sure that corporations make prudent and wise decisions for society as a whole, is correct. stakeholders in a corporation bear responsibility not just to maximize shareholder value, but to employees, to the society around them, to the users of this product. And there's no doubt that the Jewish tradition views this as a moral problem and not just a shareholder maximization problem. The externalities in environmental matters are easy to think about, and Professor Gordon's grand contribution that a low environmental filter is the same as a low moral filter, analogizing the Twitter filter to an environmental plant, is extremely astute and very much grounded in what the Jewish tradition would like to say. Corporate structure bear responsibility for making sure that they contribute to a good economic environment, and a good economic environment isn't necessarily maximized in this chart. It could be that a good economic environment vastly expands the green space, not in the environmental term green, but in the ownership of the benefits of corporate responsibility. This idea that the top 1% should maximize its wealth produces enormous social instability and injustice. And it's not just the social instability that the Jewish tradition recognizes, it's the core injustice that takes place when you run a society for the benefit of the top 1%, or the top 1/10 of 1%, or even the top 10%. The Jewish tradition thinks that Professor Gordon is well on his way to an earth-shatteringly important book, and we all look forward to reading it. Thank you very much.
All right, thank you, Professor Broyd. We have a few moments remaining for some audience Q&A, so I will roam about. If folks have any questions, I'm happy to bring the mic over to you, and I see Professor Nevitt is our first up.
Great, and thank you so much for that presentation. That was terrific. I feel like in some respects we sort of buried the lead because this slide is just fascinating to me. You have up here, particularly for the foreign ownership of U.S. equities. It is remarkable. Not my field, sort of two questions. What do you attribute this to? From 1995, it seems to go up significantly. And two, this has enormous implications for democratic governance and who holds the wealth in this country. So should we think about restricting foreign ownership? Or is this sort of more, do you have more of a laissez-faire approach to foreign ownership of U.S. equities?
You know, that's a, I haven't really figured out the implications of that, but fully. But what the way it's relevant in my thinking is, if we're thinking that shareholder voting matters, for example, the pressure that directors may feel to trade off on a social dimension in favor of a shareholder dimension. If there's a significant group of shareholders who face none of the within society externalities that would come from, say, a ruthless attitude about the employees, then they would be more inclined to take a more limited idea as to what the firm should do, right? In other words, they're not bearing the U.S.-related social costs of some of the policies that they would be voting for in the name of shareholder value. And to my way of thinking, this is, you do a talk and you sort of put it together and you come up with some stuff, So I think this is kind of a first order question, and I haven't really. I'm working with some other folks. We're trying to figure out actually what is the percentage of foreign share ownership in the United States. And this is only publicly reported that, the Fed, I assume this is not GPT hallucinating, purports to be from the Fed's statement of accounts. I've heard different figures, but all of them are like 17, 18, 20%. So this, even if it's a little high, it's not much. And so I think that's a really interesting question. The implications of it, are good ones, right? On the one hand, a shareholder value, limiting the objective function of U.S. firms in this very narrow way is a good way to attract foreign capital because they know they're going to be getting a payout on one single dimension. But for those who are in the society and observe the externalities associated with this, maybe that's not so great. And, there's been a lot of attention focused on the distortive effect of the big three, Vanguard and BlackRock and State Street. I think this is actually more important. So anyway, but thank you for noting that because it's a, sort of a thing I hope to figure out later.
Test. Professor Gordon, I'm Nick Diamond from Leaf Cabraser, and you very wonderfully provided an expert report in our Wells Fargo derivative case. I happen to be participating in this symposium over here. Wonderful to hear you. Wonderful. I have two questions. One sort of directly relates to foreign investment, which is, I assume you're noticing how actively foreign funds are now moving for lead and being selected as lead in shareholder securities fraud litigation, which is a fascinating deviation of what the PSLRA was intended to do, and I wonder what you think about that. And secondly, when you talk about morality, I wonder what you think is happening in the boardroom and whether in the boardroom anyone is talking about or thinking about morality when they're engaging with these questions.
Yeah. I'd love to see data on the extent to which foreign owners are participating in U.S.-based suits. That would be an interesting development. Obviously, the pension funds, the public pension funds and others that have been traditionally the plaintiffs, I'm waiting for the Saudi shareholder derivative, the Saudi sovereign wealth fund as a plaintiff in some of these things, challenging what the payment that Musk gets. I doubt that, but I don't know what the tenor of boardroom discussions is like. It's a black box, right? Because as you're an experienced reader of minutes, they say nothing because the last thing they want to do is give a plaintiff's attorney an opening to sort of raise a deposition set of questions with different directors. I guess what I would hope from a project like this is to legitimate a broader set of discussions in the boardroom, right? Because for a long time, there was a social consensus that the only thing for the board to discuss is the shareholder value concern, right? And I guess what I'm myself feeling as having been a proponent of that, this is kind of a heterodox move for me. Having been a proponent of that focus, I'm now, seriously assessing the implications of it. So, the goal is you begin to empower people to open those discussions within the boardroom. And, boards are like any other organization. There's a big social dimension. And if somebody is bringing up an issue, it gets discussed and it can influence behavior. And, so it's hard to know where this will lead. But the quality of boardroom discussions, it would be nice to see if they change over time. The thing is, the incentives are so powerful. Part of the project that I'm working on will be to suggest that directors should no longer receive stock-based pay. That, as I've said, incentives are not a justification for action. They can distort action precisely away from defensible legitimation. And so if directors are supposed to be the conservers, the bearers of moral sensibility within the firm, then in effect giving them incentives to look away from that is not a thing that I would support. And while I do think director accountability is to shareholders is very important, against what I've said for 30 years, I think that there's value in classified boards, which to some extent mute the immediate shareholder pressure that directors would feel and open up a space for a certain kind of deliberation. We've had unfettered shareholder value discussion, and it's produced some results which I think are disquieting. So maybe, we have to re-examine them in a broader set of goals.
Thanks, Professor Gordon. I thought one interesting fact that you brought in your presentation was that the decline in direct employee ownership correlates with increase in executive compensation. I don't think it was deliberate, but sort of happened at the same time. And I guess the question I had was for now that employees don't have direct shareholder ownership, but rather are participating in the stock market through pension funds, there's a real tension that the pension fund managers have on how are they protecting their constituents, meaning the employees. So I like the way you're posing it, because I think there is a moral angle to this tension, and is that often pension fund managers morally justify their decisions in, I'm benefiting my constituents, my employees, because this transaction is increasing shareholder value, even if it may generate, let's say, layoffs, as the example that you posed. So I wonder if you can tell us a little bit more, how do you think about the role of pension fund managers? I think there's a core tension that you alluded to. Thank you.
Look, ERISA the trustees of ERISA plans are obviously in a hard place, right? They've been sued for concerns about ESG, and have been pushed hard to think only about the shareholder value concerns. Pension plans are not that big a share of this story. They're not in the red. The pension plans are really in the green for the most part. So, and public pension plans are not subject to ERISA. And so they can act in a much broader goal set of concerns. So, there might be some folks who are legally constrained in how they can vote and act, but again, there's no shareholder who's obliged to vote in favor of externality creation by the company. That's, fact of the matter. Law does not require that.